Hi, everyone. My name is Tonya Edgerly, and today we're going to be discussing a U.S. Supreme Court case. This means that there is a constitutional right violation in question. So the court that we're going to focus on today is the Seventh Circuit Court, and they are here in the trial of Jason Ostby, Jill Ostby versus Manhattan School District. This school district is located in Illinois, and there is a child whose parents feel that the school district is advocating for a more restrictive environment than is necessary. A few key terms that we're going to focus on before we jump into the case is individualized education plan, mainstream, least restrictive environment, Individuals with Disabilities Education Act, free appropriate public education, stay put order, and moot. So we have three very specific important dates in this case. There is the March 6, 2014 IEP meeting. This is the meeting at which there was a recommendation made by the school district to change Jason's current mainstream placement with the special education services to a SELF program, so a social emotional learning foundations program. April 25th, 2016, the case is brought up to the Supreme Court level. There has been an administration hearing at this time, as well as a district court level hearing, all of which cited that the school district was not in violation. And then on March 16th, 2017, a judgment is made at the Supreme Court level in this case. So we have two opposing parties. We have the Jason Ostby and Jill Ostby, and they are the parents of a student named Jacob. And then we have the Manhattan School District, which is where Jacob is currently enrolled. So Jacob Ostby, he has been enrolled at the Manhattan School District with an IEP in place since he was age 4, since he was in preschool. He has obtained the diagnosis of attention deficit disorder, as well as the hyperactivity piece of ADHD and disruptive mood disorder. These outbursts of emotions and difficulties with self-regulation have hindered his education in a mainstream classroom. So the school district has made the recommendation to change his placement to the SELF program. Since the SELF program is located outside of the school district, the parents file for that due process hearing and disagree with this recommendation. They feel that it's in violation of his free, appropriate public education and least restrictive environment. At this time, parents are also paying out of pocket for additional testing. They are also paying for evaluations, and they are paying for a private psychologist who comes on board to support with the IEP process. And they continue to disagree. So the court is faced with deciding if the 14th Amendment is being violated by the school district. Are they violating Jacob's rights under the IDEA? Is he not getting that free, appropriate public education? And is this recommendation the least restrictive, or is the mainstream the least restrictive? And the key to the least restrictive environment is the child must be able to also succeed academically. So if he's not succeeding in mainstream, is this an appropriate placement for him? So the court ends up deciding that the family will be reimbursed for those out-of-pocket expenses that they have paid for that psychologist, additional testing and evaluations. There is a ruling that there is no party responsible for each other's attorney fees and legal fees. That is to each individual to pay. The case itself, in regards to the constitutional issue, is that it is moot. This is because at this time, when this was filed, it was first grade. By the time that the court is reaching the decision, Jacob is in 3rd grade. This is a 3rd grade IEP that has been agreed upon between both parties with the recommendation of mainstream by the district, with no intent to change that recommendation. So the case no longer has controversy. We are no longer in 1st grade. There's no longer a recommendation for the SELF program. The court cannot make a ruling if there's nothing to rule on. So the case becomes moot. There's been too much time that has lapsed. There's also the piece where the parents want to put in place that in the future, the district cannot recommend the self-placement. However, when it comes to the court, they can only rule on current controversies. So this is a past controversy that has been resolved outside of court. They cannot rule. There is a potential hypothetical controversy in the future. The court can only rule for current. So the case by default becomes moot. So why is this case even important in special education? Well, it continues to uphold the similar findings in other cases that are similar to Jacob's case. It prevents conflicts from continuing in a court system when they've already been resolved. And it also prevents the court from ruling for futuristic hypothetical possibilities and situations. So under the 14th Amendment, we have our IDEA, our FAPE, and our LRE. These are all constitutional rights of protection of equality at the best possible setting, in the most appropriate setting, which may not always be public mainstream school, which is why we have the least restrictive environment included in this whole act, because everyone is allowed to have equal access. Equal is not identical per se, setting wise for a child, because they need to equally be able to access their education. If they can't access their education in mainstream, that's not equal access to that education. So they need to change their environmental setting so they can be successful. So in the case of Jill Ostby versus Manhattan School District, the US Supreme Court rules correctly. They uphold constitutional rights and protect the financial obligation of parents when it comes to receiving evaluations and additional supports for their child, because the parents are reimbursed. But for this case, it must be moot. Many resources are available. These are some of the key ones that I had found. However, if you have additional questions or comments, feel free to email me and I will do my best to respond to those and answer them to the best of my ability. And otherwise, I hope you have a wonderful rest of your day. Goodbye.